Good afternoon, ladies and gentlemen. Welcome to the second episode of the APAA Trademark Caravan. This year, we shine the spotlight on Myanmar, the second largest country in Southeast Asia. The new trademark law of Myanmar, which was passed in 2019, came into force on the 1st of April this year. With the support of the Myanmar Recognized Group, we have lined up a sparkling panel of senior government officers and experienced IP practitioners of Myanmar to bring to you this webinar. We will leave questions and answers to the end of the webinar. If you have any questions, please type in the Q&A box. And do not forget to provide your name and your email address. This way, if we are unable to answer your questions during the seminar, we can reply to you after the seminar. Without further ado, let's welcome our keynote speaker, Dr. Htwe, Director General of the Intellectual Property Department of the Ministry of Commerce of Myanmar. Over to you, Dr. Htwe.
Thank you very much. And thank you very much. First of all, I would like to say my sincere thanks to ASEAN Patent Attorney Association APA to deliver as a keynote speech for highlighting the Myanmar progress in IPR protection. So let me share some progress in Myanmar regarding with the IP protection system. So as you all know that, next one. All you all know that Myanmar is implementing the trade-related aspects of intellectual property rights trade agreement according to our obligations as a member state of WIPO and WTO. And also, we really understand well that the IP protection is really needed for Myanmar regime and as well as to use as a economic tools to have it innovation and creation promotion, and as well as fair competitions in our trade market. So, and also Myanmar has been implementing the ASEAN Framework Agreement on Intellectual Property Cooperation. Although we haven't had it, the IPR laws in former time, we start from the member state of the WIPO. We continuously involving in progressing for setting up the IPR new regime in Myanmar. So Myanmar is quite keen interest for promotion and protections of IPR, and as well as we try to establish the necessity institutions regarding with the new IP regime that in line with the international agreement. So regarding with our Myanmar, next slide. Regarding with Myanmar IPR protection, the basic needed is the IPR laws. So we have been trying for drafting and propagations of the IPR laws, such as trademark law, industrial design law, patent law, and as well as copyright law. These IPR laws were promulgated successfully in 2019. So in this law is mentioned that there are 3 steps of the IPR institutions, such as the IP Central Committee, IP Agency, and IP Department. So they have a different role in order to have an efficient and effective implementations of IPR laws. So next slide. So as you know that we are start from the adoptions of the IPR laws, but we haven't enforced it in these the days before this year April. That we are preparing continuously and taking great efforts to carry out to implement the these 4 IPR laws. So that is why according to our IPR laws, FOCA Ministry taking responsibility for implementations of the IPR laws is Ministry of Commerce. We have to be work together with the Ministry of Information, Ministry of Industry, Ministry of Agriculture, Livestock and Irrigation, Ministry of Education, and Ministry of Science and Technology are the relevant ministry that we are working closely together with other ministry as well. So next slide. Yes, next slide again. The organization structure that, as I said to you, next slide. IB Central Committee is chaired by the Deputy Prime Minister, and IB Agency is chaired by the Secretary of the Central Committee, and Intellectual Property is headed at Director General level. So in this sense, IB Agency and Intellectual Property Department, IBD, are taking responsibility for implementations of the IPR laws. IB Central Committee, in that case, they are taking a role for setting up the IB policy guidelines and strategy as well. So next slide. Our vision, last slide. Our vision is, as I showed to you, to establish a modernized intellectual property system for the development of business ecosystem. So to reach this vision, we have 3 steps of mission that we would like to be encourage IP utilization, and also to provide reliable IP service, and also to promote IP cooperation and coordination. So that is why we try to setting up the IP strategy for 3 years plan. In such a sense, we have it kind of IPR action plan that have already done in 2016, but we now update it for our year plan that after promulgations of the IPR laws. So that is why in our next slide. So in our strategy, according to this is our kind of roadmap and strategy, in such a sense, there will be 6 steps. So strengthening IPR laws, rules and regulations in setting up the intellectual property system. The second goal is the strengthening the IP protection system by encouraging the utilization. And third is the promoting the innovation and creation by the protection of intellectual property. The fourth one is the raising IP awareness and human resource development. The 5th one is promoting the regional and international IP cooperation and coordination. The last one is the preventing the infringement of intellectual property rights. So next slide, please. So regarding with the IB Central Committee, we have already setting up the IB Central Committee. That is a member of 33, that included the 33 members. And we have to reform again and again, according to the changes of the Ministry of Concern. So we have already done for our IB Central Committee meeting as well. In that meeting, our IBD reported the policy that we would like to be going forward, and that we received the suggestions and guidance from the members of the committee as well. So we also going forward regarding with our roadmap that was setting up by the IB Central Committee. And also we have already setting up the second institution like IB Agency in 1st April 2023. So next slide, please. So according to the law itself that I mentioned in here, so we have already mentioned 80 members of the IB Agency. So IB Agency will taking the major role for promotions of the IPR, and as well as for the many responsibility that it mentioned in our IPR laws as well. So we also drafted the IB Agency rules that was now ready to submit it to the Ministry of Law to get any suggestions or comments on it before we adopt it. So Intellectual Property Department was established under the Ministry of Commerce on 23rd December 2020. So we are starting this drafting of the IPR laws under the Ministry of Science and Technology or Ministry of Education now according to the laws, and we have to move to the Ministry of Commerce. But next slide, please. So according to the implementation plan, according to our roadmap of IP strategy, so as you see that we will implement it step by step. So trademark law is the first stage. Then we have already adopted trademark enforcement in 16 April 2023. So in this figure is showing that in after 6 months. So meaning is that 31st October is the last date, 2023. Then we will enforce, we will enter to enforce the industrial design and copyright law. And after 1 year, after trademark enforcement, let's say that the tentative month is May 2024, that we are trying to promulgate enforce the patent law and as well as GI protection system in Myanmar. So next slide, please. And this figure is showing that how we have to be implemented the trademark law. So as you all know that Myanmar is currently we are using before adoptions of the IPR laws. We are using the first to use system for trademark registration. So in such a sense, all the old trademark in our market that had to be transferred to the new law under first to file system. So that is why we plan it to have it the two-step. And firstly, we open our acceptance of the trademark applications for intentionally to collect it, the old mark in the market that we so-called is soft opening in 1st October 2020. So in such a step, we give it the chance to the representatives of the trademark, the law firms and the others company to use as a web profile account user to apply the old trademark in their hand. And as well as we are unfortunately this period is longer than we expected, and we have it at a good chance to enforce the law in 1st April 2023. So then in 26 April 2023, we launched the grand opening of the trademark registration. In such a sense, after grand opening, and we accepted that old mark as well as for the new mark for registration. For the first step applications and the second step applications then we treat it we treat it in same manner. Our first filing date will be 26 April 2026. So for applications of the trademark, that we offer it in two ways. One is via representative, and one way is by the personal or the trademark owner personally, or they can apply to our reception counter. So in that sense, our IBD is continuously accepting the trademark application since 1st October 2020 at the up to date. So currently we have already received more than 50,000 of trademark applications, and we have been starting the examinations for the applied trademark since 26 April 2023. So we will, next slide, please. Regarding with the trademark law, so as you all are seated, the 1st October 2023, our trademark law is time into force. And 26 is a grand opening or trademark registration system. After grand opening, old mark and as well as the new mark simultaneously, we can accept it. So applying for trademark application for registration, they can come up via electronic filing system that with so-called web mobile system provided by the WIPO, and as well as the over-the-counter, they can come up at Naypyidaw, Yangon, and Mandalay Reception Center. So we started the examination after appointing the registrar examiners by ministerial orders in May 2023. So we have already started the examinations for trademark applications. So next slide, please. So according to our system, we need a skilled representative in our Myanmar for helping the clients to successful registrations of the trademark applications. In such a sense, our IBD offering training module for a week for the future representative of trademark applications. So 2022, we have 2 training, and 2023, we have done 2 training as well. Total 349 representatives have already given the certificates. So as all listed, you can see it in our website as well. So next slide, please. For trademark information, well, we make a very user-friendly mechanism. All our trademark law and regulations that we have been uploaded in our website as well. And also we are preparing for the user guidelines and reception counter application process as well. We declare how they have to do, and they have to follow how the procedure. Then registration process, trademark classification, trademark represented all the information we provided for the trademark users for Myanmar. So next slide, please. In here, you can see that our publications regarding with the trademark registration process. There are several travel advertisement, and also the guidance release paper from our Ministry of Commerce. So next slide, please. In this IBD website, you also can see that all the trademark application, trademark application, they can be freely download, and as well as all the facility they needed. Also, all the information we provided in our website as well. So next slide, please. In this slide, you can see that needs classification for trademark representative or trademark owner. They need to understand about the classification that they would like to be to use it for their trademark as well. In such a sense, we give it all the information and link it to the needs classification and the website of the WIPO, and they can learn from here. And as well as we translate it, the Myanmar version, and they can be learned to have it right decisions for trademark classifications for their respective registration. Next slide, please. And here we declare that the registration process according to our trademark law. So we will examine formality and absolute ground examination, and then we will publicize for all the applications batch by batch. Then there is no opposition, and we will directly grant and give the certificate. If there is there's some opposition is happening, we have to examine on that specific cases. And after that, we will decide it, grant or refuse, and we will publicize. And also if our deposit for registration, and we can give it after that certificate. So as you all know that Myanmar is changing first to use system to first to file system. And also we were going to use the pre-grant opposition system, and also the applicant can be appealed if they don't please the decision made by the IBD. So IBD registrar. So this is the detailed procedure that roughly they can be understand. The next slide, please. For enforcement mechanism for trademark infringement, and we have it different department under the other ministries, and they have a customer regulations judicial procedure. So they also announce and publicize for their respective website. And also we will give it the IB consultant, and also we will going to use the alternative dispute resolution, and if they interested, or for future dispute settlement. Next slide, please. So apart from the IBR laws, IBD really trying hard according to our roadmap, as I have already told you. In October, coming October, we will going to enforce 2 IBR laws: industrial design law, copyright law, and next year will be trademark law. So forms and fees and all are ready, and we have already have it a kind of good comments from the Ministry of Laws and other ministry as well. So we are now submitting to get the approval from our government, and so currently under processing the internal procedure. So we hope that according to the timeline, and we can be successfully enforce all these laws in near future. So next slide, please. Myanmar is now opening the IPR new regime for future the economic system development by using IPR as a tools, one of the tools for economic development. So we are trying to set up IP management mechanism by our MOC, Ministry of Commerce. The IP policy and national IPR strategy plan we have already now updated and will be adopted in next Central Committee meeting. And our IPD also are given good awareness and also collaboration with other ministry of concern that I have already shown you. Then we will really encourage to setting up that is central service center and also industry collaboration with the university and research center, and then to promote the IP protections and IP creations, IP utilization system. So that IBD is putting great efforts to have it such kind of mechanism. We really trying very hard to go forward. Next slide, please. So as you all are aware that Myanmar is now developing IP system infrastructure, promoting education awareness on IP in all sectors. So that we hope that the application sector that we so call encouraging IP creation, strengthening IP protection, and also promotion of the IP utilizations in for our university SMEs and all the creative sectors. So that we intend to promote technology and knowledge-based investment and economic growth that we hope to get it such kind of benefits in the future. So raising IP awareness, next slide please. Raising IP awareness, we use the different types of IP awareness in setting up IP system, and enhancing the human resource and raising IP awareness are the really important for understanding, make use of the IP system. So that's why we give it several informations and several posters for disseminated the IP informations in all sectors. So next slide, please. In here, you can see it, IP awareness for MSMEs in different regions of Myanmar, Htwe, Patay, Bago, and Molmia. And also we give it the IP talks in university and research institutes to understand how the IP system that they need to make use of it, to promote it, their innovation and creation in all universities and research institutes. We have already signed SLA with the WIPO, and as well as we also signed an MOU between the universities and the research institute. And we started with the 5 universities and 1 institute to more understanding how IPR is important for their innovation and creation in their respective settings. And next slide, please. In here, you can see it. That we also give it the IP awareness in disseminations of the IP protection system, and giving the pamphlets that included that the IPR information that explaining our IPR stuffs to all the learners for the MSME Expo. That are one of the figures that we're showing to you. The awareness activities, we have done several awareness activities in virtual as well. So we in this year we assume that this year is the IP promotion year. So that is why we do it in several ways to disseminate that IP information in all sectors to make use of IP system that we are going to set it up here and future. So next slide, please. So all the IP informations, updated information. Next slide, please. Next slide, please. All the IP information, updated information up to now, you can see in our Facebook page, IP Myanmar, official website, www.ibd.gov.mm, and the YouTube link, IP Department Myanmar. So all the information we give it openly to see how we are doing the IP implementation, IPR implementations in Myanmar. So you all can easily get all the information regarding with the IP protection system that we are going to conduct it for implementations of these IPR laws. So next slide, please. So this is one of the researchers in Yangon. So help desk also we setting up, and also consultation program also we are setting up in our website, and everyone who interested to get the information from our department, we explaining and we give the good service and also any consultation so that they requested, and we give it as much as possible. So thank you very much. And these are all the information that I can be shared to understand how our Myanmar is really putting great effort for protections of the trademark registration system in Myanmar and others IPR law as well. Thank you very much for your kind intention. Thank you.
Thank you, Dr. Momo Htwe. Thank you for the very informative talk, telling us about the preparation and the implementation of the IP regime of Myanmar and the roadmap. So we are expecting all the IP laws to be implemented by the middle of 2024. Thank you very much.
Thank you.
Now the next speaker is Ms. Khin MYINT, who will talk to us about the IP history of Myanmar to put things in context. Ms. Khin MYINT, please.
Okay, thank you.
And could the IT administrator please share her slides?
Yes. Kalan, yes. Hello.
I think the IT administrator is trying to share. Yeah. It's a little bit slow. Yeah.
Okay, thank you. Good afternoon, all participants. Greetings from Myanmar. My presentation is IP history of Myanmar. So in my presentation, I would like to highlight the legal frameworks of IP protection in the past years before 2019, since we have already enacted 4 IP laws in 2019. First slide. Next one. Yes. So in Myanmar, formerly a British colonial territory, follows a common law legal system. Myanmar's frameworks for IP protection have for decades been well protected by a combination of common law principle, criminal law, and established practice. There is no specific law for the industrial property, especially trademark, and only law for the intellectual property is a Copyright Act. General laws and IP special laws for IP related laws can be seen here. These IP and related laws are very outdated because they are enacted in the 19th and early 20th century. Next. Historically, before 2019, there is no specific law for registration of trademarks. However, trademarks can be registered by means of submitting by means of declaration under the Direction 13 of Inspector Generals of Registration and the Registration Act. And it is handled by the registration office called the Settlement and Land Record Department under the Ministry of Agriculture and Irrigation. So under this direction, an applicant can find by submitting of the 2 documents, Declaration of Ownership of Trademark and the Power of Attorney. Declaration of Ownership is a document in which the trademark owner or applicant declares that they are original owner, creator of this particular mark. Power of Attorney is a document to appoint an agent for the registration process. Power of attorney from non-resident trademark owner must be notarized by the Myanmar Embassy. Next. So after registration of the declaration of ownership, usually follow an announcement in daily newspaper and other publications to prohibit of the fraudulent imitation and unauthorized use and infringement and so on of the trademark. It's called the cautionary notice, but it is not mandatory and required. Trademark can be registered, as I said, but there is no such system, examination system for the granting of the ownership of trademark. So at that time, registration does not automatically give the exclusive right, and then there is no specific term for the trademark, and also no need to renew. So when occur infringement, the owner may sue. The owner may send a cease and desist letter to the infringer to reach an amicable solution as a first step. And as a second step, can file a suit at the judicial court for infringement suit and claim for the compensation and injunction under the Specific Relief Act at civil action, and then or take criminal action under the penal code. In post-independence, we have learned in early case law, it is determined certain cases in accordance with the principles of English common law. Trademark protection is generally recognized under the rule of common law, and its first-to-use system is appreciated as the basic principle of the trademark protection. So, next slide. So this is the patent and design. So we have only two laws, the Myanmar Patent and Design Act and the Myanmar Patents and Design Emergency Provisions Act, 1945 and 1946. But both are never brought into force and never been used actually in Myanmar. And finally, these are repealed in 1993. So, and innovation patent and design may be registered under the registration act at the same system as the trademark registration. So other related laws are mentioned here. Next slide. So for copyright, before 2019, copyright protection in Myanmar is governed by the Copyright Act 1940. So copyright protection covers various forms of the creative works, including literary works, artistic works, musical works, and dramatic works. This protection extends to both published and unpublished works. It does not require copyright registration and automatically granted to the creator of the work. And copyright can be transferred by means of assignment and licensing. When copyright is any work has been infringed, the owner of the copyright may sue an infringer for an injunction to seek the infringement, claim damages, and other related remedies. And copyright infringement can be also taken under the criminal action. Next slide. When occur dispute between any infringer and the creator of work, settle amicable by means of negotiation, conciliations, or mediations with the intervention of some non-governmental association. Some associations can be seen in this slides. So other than the Myanmar Copyright Act, the other related law can be seen here. Next. 90. Okay. So when occurred is, Myanmar is a member of the several international conventions and agreements relating to the intellectual property. Myanmar joined, firstly, WTO in 1994, become a ASEAN member in 1997, and also became a member of WIPO in 2001. It becomes responsible to observe and be in line with the provisions on the provisions of the relevant IP conventions, particularly TRIPS agreement and ASEAN Framework Agreements on the IP. So historically, as I mentioned, Myanmar had no specific intellectual property related law in place before 2019, except the Copyright Act of 1940. However, significant changes occurred in early 2019 when a series of new IP laws were introduced. These include the Trademark Law, Industrial Design Law, Copyright Law, and Patent Law, which are subsequently enacted in order to provide businesses and individuals with protection for their intellectual property rights that are in line with the international standards. Next. Finally, I would like to share the updated information, which is the current legal enforcement for IP rights protection in Myanmar. So among the 4 IP laws, the trademark law took the lead and became enforceable on 1st April 2023, as already mentioned, presented by Dr. Htwe. In Myanmar, the responsibility for IP rights registrations lie with the Intellectual Property Department, IPT, under the Ministry of Commerce. Notably, this department recently initiated the acceptance of trademark registration starting from the 26th April of 2023. This development provides an opportunity for the trademark owner to secure their trademarks and reinforces the significance of prompt action in safeguarding their IP rights. In order to obtain legal protection of trademarks and to ensure the registered trademark rights is called rights of priority under the new trademark law, all existing registered mark and trademarks in Myanmar must be re-registered under the new system. As first-to-file system has replaced the previous first-to-use system because it will not be automatically recognized under the new law. This new system is the same system as the other systems. That's why existing trademark owners shall submit their registration application to IPT via online facility or at the over-the-counter within 6 months after April 26, 2023 is called the grand opening date until October 25th, 2023. Therefore, I strongly urge to all of the trademark owner to consider registering your marks with the IPT before the deadline 25th October 2023. If you wish to secure protection for your trademark and to obtain priority rights over the trademark. So based on the information gathered from IPT and the newspapers, as mentioned already by Dr. Htwe, the copyright law and industrial law are set to be enforced in October and November this year, respectively. So subsequently, the patent law will be enforced in the following year. Here, I encourage you to stay informed and keep an eye out for this development as they will enable you to safeguard your IP rights through formal registration. So thank you so much. TJ procedure for the registration of trademarks under the new law will be presented by the next speaker, Mr. Aung Khine OO. Thank you so much for your kind attention.
Sorry. Thank you, Ms. Htwe. The next speaker is Mr. Aung Khine OO, who will talk to us about the registration system under the new trademark law of Myanmar. Over to you.
Thank you. Hello, I'm Aung Khine OO. My name is Danny as well. I'm from Myanmar. I would like to present about registration system under current law for EPA Caravan 2023. It's an honor to present my presentation. I would like to start with the development of the new trademark regime. It is already taught, already Ms. Momotwe and also Ms. Infringement already talk about it. I would like to talk about some brief. So in 2019, trademark law is enacted, and we have a soft opening period, which is the 1st October of 2020. And in that soft opening period, we have to apply for trademark representative, and we all have the accounts, e-filing account for re-registering the old trademark into a new e-filing system. These accounts are given to the representative, TM representative. In this new trademark system, what we can register is two types. One is a trademark which has been registered under previous system, and also the trademark which are using under the current using in the system. These two marks can be re-registered in the soft opening period. And also there are some announcement about the TM2 form, which for the foreign clients, which can be submitted in the, they can combine in the single document, And then later on, the trademark rules came out in 31st March, and then we have the enforcement on April 1st, 2023, followed by the fees, bounds and fees together. And then starting from April 1, we can do payments starting from April 1 and until May 31st. But the grand opening is starting on April 26th. So we have the the payment for these soft opening application will be starting from April and then May, and then later on it's extended to June 31. This is the brief what we are doing at the moment right now. So this is a comparison of the old trademark system and then new trademark system, which is already told by Ms. Lilian. So I will skip this. Right now, for the new trademark system, you can do two types. One is the online, and another is an online. Online is the system given by the IP department. Right now it is able to do by the representative. But for the foreign applicants, they have to do TM trademark application through representative, either maybe online. Next is the trademark registration process, which include application, examination, publication, opposition, and also the registration. And there are also appeal process if you don't desire the decision from opposition or maybe from registrar. Starting from application, you will need to know about the mark definition. So in the mark definition, in section 2J of the trademark law provides that it is basically a conventional trademark, which includes like names, letters, numerals, and some figurative elements. So in the next slide, what we have the type of mark which are allowed in current system are the word mark, a figurative mark, or combination of these two marks. And most importantly, three-dimensional mark is able to be registered, and also color and their combination will be able to register in the current system. Right now, the type of application type is also mentioned. So right now, normal, a new trademark application, including collective mark and certification mark. And also right now, we can still do trademark re-registration, also known as number 2, old trademark re-registration, old certification mark re-registration, and old collective mark re-registration. So these are the types and the type of mark and the application type that are accepted by the current online system. So as as you progress to the application system, we have to know about that trademark application requirement. So we have to know, firstly, have to know about the applicant name and their ID. Applicant can either be an individual or maybe either individual or the company, or maybe collective some legal entities and their address. And we also need to provide their ID like passport if it's individual, or maybe for national it's what we call NRC card in the as a trademark ID. And also we need to provide trademark name. And if your trademark is in a figurative form, you need to provide a logo, and this logo need to be clearly represented. If in case of the trademark like Chinese character, Japanese character, we should be able to provide translation and their transliteration, basically a sound, how we pronounce. And also color claims. If your trademark needs to do color claim, you need to do present color claim and priority claim if necessary. The most important one is a niche class. Right now we use niche class to present a type of protection you wanted in the application. Last in the TM1, the trademark application form, representative is also if like foreign applicants, which we're doing with the representative, they will need to provide a appointment or representative form. We call TM2 form. These trademark application can be done in Myanmar or in English language. This is the sample draft for TM2 form, which includes the data like application number, references, and also applicant data, representative data, and also mark data, and also niche class that you want to protect. And then you can also submit like evidence for like re-registration of trademark that has been used in Myanmar. And also represented, if TM2 form is required, you have to provide a TM2 form. In TM2 form, you will need also like applicant name and their address and their ID. And also we need to provide our representative name and also the address. And then for each TM2 form, we need to provide trademark details, like what trademark we would like to provide in this form. And also the rights. The rights are like withdraw the rights given to us like from the applicant, like it is that that appointment or representative is only for maybe for application, or maybe for withdrawal, maybe for opposition, and so on. The applicant can restrict based on their application. As for the foreign applicant, this TM2 form need to be notarized in their respective country. And for the foreign applicants, in the TM2 form, you can add multiple trademarks into a TM2 form. And for the criteria of representative need to be a Myanmar citizen, which is living inside the Myanmar. It need to be a natural person to become a representative to do IP matters in Myanmar. It need to be like 18 years old, that is mentioned by the law, and also have the national registration card, we call maybe NRC card or NI, national identification number. Sadly, foreigner cannot be a representative since it is barred by the trademark law. And also law firms are legal entities, so they cannot represent as a representative. This is the TM2 form that I mentioned. It includes like applicant details, representative details, and trademark data, and also the rights given by the applicant, and also the appointment date. okay, we know about the TM2 form and then the filing requirements. So we start with the application. After we start submitting the application, we will have we have to do the payment. And after the payment, we will get the filing date. In the soft opening period, the filing date start from what we done in like re-registration process. It will start from October 1st until June 31st. They will get the filing date of 26th April 2023. After you get the filing date, you will have the examination. Examination will be formal, only the minimum requirement, only for formality and absolute ground. While in the examination, there are some process we need to like amend the class that are too broad or something like that, and then we need to fulfill the IPD for some requirements. Which has to be done in 30 days. If you do not fulfill the requirement, the application will get abandoned. But however, you can still revise within 60 days to become your application to be live. After examination, the IPD will announce for publication within 60 days. You can oppose the application from the third party. If there is no opposition, you will get a registration. In opposition, only if there is some opposition, there will be an opposition case. In that opposition case, substantive examination will be examined, like whether like the trademark is similar or not, something like that. It will be only considered only in opposition. When your trademark application is granted, you will get a registration. If it is refused, you will not get a registration. But however, you can still do appeal to the agency within 60 days from the decision. And also you can still appeal to the court within 90 days from the decision from agency. The official fees are announced, but for the one trademark in one class will be 1,000 and 150,000 or $75 per class, both for application and also registration, in total of 3 lakh 150 USD in per class. And for the term, we'll get 10 years, which is similar to other countries, and it is renewable. The forms and fees are provided here, so it includes every single steps in our process. There is also like record like transfer of ownership and recordation are also provided also here. You can still do assignment here as well. Last but not least, I want to tell about some challenges in the new system, because it is completely changes from first to use to first to file system. So IPD has some technical difficulty at the very start. So they have to start from scratch, start from zero data, and then they have to do a lot of training, something like that. They also have difficulties. But on the framework owner side, so they also have the difficulty because if they don't know the first to file system, they will not be able to get protection under the new system. And for us, the framework representative, we haven't done all the full process, so we have not gained some good experience like opposition, office action, etc., to fully get the registration. And for the payment, they are not very smooth, according to my experience, very at the start of the system, And then also the court judges are very new. So they have to switch from the common law system first to file system. The formal system is first to use. So there have been some legal issues like overruling some cases in that matter. So the courts will also need some more experiences. And also for the customs, there will be some new procedure, so they have to follow. So we will need to look out for that. And also, I would like to suggest these three agencies, like from together with IBD, customs, court, police, so that these agencies will need to be in cooperation to get our framework enforced effectively. And also we go to the trademark definition. What we see is the trademark, the trade dress is not mentioned in this current system. So it is quite difficult for the owner to get a trade dress or get a system in registration in current system. And then series marks are not accepted in the new law. If the trademark owner can want to apply for series mark, they have to do it individually, single trademark in one application. And also lastly, the protection between transitioning stage phase. Right now, all trademark owners are re-registering their mark, but not get their mark registered fully. So they are not protected fully under the current system. But however, when we go back to the old law, it's first to use system. So it is some gap between some lack protection between the this period between the transitioning phase for the TM owner to get like enforcing some infringement and counterfeit something during. It's hard for the trademark owner to do within this interim period. Thank you very much for the presentation. It's a great honor for me to present in this APA seminar, APA Caravan 2023. Thank you.
Thank you, Mr. Aung Khine OO. There are some questions in the Q&A box, and perhaps you can take a look and answer if it is relevant to your part. Now, the next speaker is Ms. Thaw Min LWIN, also known as Lilian. She will be talking to us about the examination of trademarks under the new trademark system. Lilian, please.
Hello, everyone. 1 second. Oopsie daisies. Okay. Let me just go back to everything. Good. Hi, everyone. I'm Lilian. I'll be telling you about how the examination for the new trademark system is going to go. This is going to be a little short since we don't have a lot of experiences yet, so we'll be going with more theory than examples, just a note. So, to give you a quick recap on how things are going to go, I know we already talked like 3 times, but so here we go. So first, there's going to be the application. Mr. Aung Khine already told you about that. And then the IP office will publish a cautionary notice to the public for any third-party objection. Right after that will be the examination of the IP office. And then you're done, registration, right? Now I'm going to tell you about the third point, the examination. So the trademark examination is going to be basically 2 sections, I suppose. First, the absolute grounds, and then the relative grounds. And for the absolute grounds, is according to Section 13 of the Trademark Law. First of all, going to need to be distinctive. And then it cannot be in any sense, as the trademark should not be generic, and it should not affect any public morality, religion, any faith that the people have in customs. It cannot affect anything like that. And then any common usage words or slang in Myanmar, because that can, get to generic. So then it cannot mislead any consumer. Using flags, emblems, any official signs that are authorized by the country, or any emblems of international treaties that include Myanmar. Now, so how do we find out what is distinctive? Like, how do we grade things in Myanmar? Now, and then the IP office, we were told that they will be using the 4 strengths, if anybody is familiar with it. First, we have the strongest type, the arbitrary or the fanciful mark. Next, we have the suggestive mark, which is slightly less weaker, I suppose. And then you have the descriptive mark. And of course, the generic marks that are just a dream that cannot come true. Now, I'll get to the strongest part first, which is the arbitrary or the fanciful. Now, as I said before, the arbitrary or the fanciful type of marks are marked as the strongest, because these type of trademarks have absolutely no connection to the products, whatever they're selling, according to this logo. And the reason I put them together is because fanciful marks also have no connection, because they are either coined or a made-up word that does not exist in the dictionary at all. So that's the strongest type, which is supposed to be the best. If you want to register, you go with this one, right? And then we have the suggestive marks or the descriptive marks. And I put these two together again is because there's a fine line, and not very fine line, between the differences between the suggestive marks and the descriptive marks. So it's a very easy line to cross, I suppose. So the trademarks, these type of marks are they as the name says, they either describes or suggest what the type of product they are trying to sell. And oh, sorry, I skipped that. So the descriptive marks, sorry, I think my tongue is not working today. So the descriptive marks are worse than the suggestive, weaker than the suggestive marks I said before. And if your marks are descriptive, the word, you will need a secondary meaning. And when I say secondary meaning, it usually means any type of legal document that can prove that your trademark is distinctive. For example, like surveys, advertisements, for any type of prima facie evidence that can prove that you've used this trademark before, or dictionary meaning. Like if a dictionary meaning says your mark means A, but what you're going for is your trademarks is gonna point to your logo and nothing else, and you need to prove that. And we don't have any like example cases, so it's difficult for me to show you what I mean in this secondary meaning. But if you cannot show, then your mark will be generic. So it's a this is the most dangerous field. But if you can show that your mark is distinctive, then it can move to the suggestive marks. Or if your mark is suggestive, then you won't necessarily require to be any secondary meaning. But like I said, there's a fine line between suggestive and descriptive, because when your mark is suggestive, it depends on how suggestive it is. Because suggestive usually means like indirectly means how descriptive, I suppose, descriptive in a synonym to the product. So when your mark is either too suggestive to the part that it's descriptive, or it's not that suggestive, and it requires a lot of brain thinking to get to the product. So yeah, so proof that your mark is not as descriptive and it doesn't, and it's distinctive to the eyes of the consumers. Now, moving on to the relative grounds. And according to section 14, says that it cannot be similar with a senior trademark, the one who has an early register. It cannot have a likelihood of confusion. Okay. And then it cannot be similar to any official marks or legal organizations without permission. Then it cannot affect the IP, the rights or the IP rights of any others. It has to be in good faith, and it cannot be similar to a well-known mark. And it cannot dilute other registered well-known marks. And if for anybody who has are not very familiar with the dilution, it usually means you're misleading another's trademark. And misleading, when usually we say you're faking other people's mark, but no, usually dilution in this case just just makes you confused to the point that you don't even know which one is real or which one is fake. So and when that happens, the owner who has the registration of the well-known mark will lose its distinctiveness. I would like to explain to that. And I am done. Thank you for your attention. And for my APAA friends, I hope to see you in Singapore. Thank you.
Thank you, Lilian, for explaining the examination criteria for trademarks. Now, since we are slightly over time, we will go directly to the next part, which is about enforcement of trademark rights in Myanmar. The first speaker under this session is Ms. HNIN, who is the Assistant Director of the Preventive Division, Myanmar Customs Department of the Ministry of Planning and Finance of Myanmar. So over to you, Ms. HNIN.
Thank you, Rebecca. And let me share my PowerPoint slide. Or can you see it?
Yes, we can.
Yeah, okay, thank you. Hello, everyone. Good afternoon from Myanmar. And I'm sorry, my voice is. I'm HNIN. You can call me just Su, because for some people it's difficult to pronounce, so just Su is okay. And Assistant Director of Myanmar Customs Department. And today I'm going to explain about the customs protection under the new Trademark Law. Okay, now it's what. And in my presentation, there will be mainly 5 parts. The first one will be the outline of organization, and the second will be the peer legal framework of Myanmar. And the third one will be the difference between TRIPS agreement and current Myanmar practice. And the fourth one will be challenges, and the last one will be the future plan. For the first one, I would like to explain about our organizational structure. Myanmar Customs Department is under Ministry of Planning and Finance, and we have 12 different divisions. And among them, intellectual property section is located under Prevented Division, and currently we have 4 officers and headed by me. Currently we don't have enough officers, but we are doing our best. The main function of IP sessions, we accept and review the application for the recordation or the suspension application. And after we review the application letter, and we notify to the applicant whether the application are granted or rejected. And we keep the confidential information of the right holder not to be disclosed to unresponsible person. And we do as a communicator between right holders and frontline officer for enforcement. And we handle and we manage the suspected goods according to DG's decision or court decision. And we are also responsible to develop rules, regulations, and standard operation procedures for customs officers. And we organize awareness sections and training not only to the customs officer and also for the public sectors. And the next will be the IPL legal framework of Myanmar. In Myanmar, currently we have 4 IP law, and those are promulgated in 2019. And among them, in trademark law and copyright law, in Chapter 21, customs code for border enforcement is stipulated. Today, I'm going to talk about the trademark law. In Trademark Law, Chapter 1, Section 1B, mentioned about the law shall come into force on the date prescribed by notification by the President. Therefore, on 10 March 2023, the State Administration Council issued notification letter number 82/2023 to set the effective date of the trademark law from 1st April 2023. And after that, Ministry of Planning and Finance issued notification letter number 50/2022 for the customs rule relating to protect of trademark right and trademark right from 14 July 2023. Okay. Okay. This is the flowchart of application procedure for recordation or suspension. And firstly, the applicant can send application letter after they receive approval of their rights from IP department to customs department. So we customs department review the application form and notify to the applicant whether their application are granted or rejected. If the application are granted, we will suspend the suspended goods when those goods are entering into Myanmar, and we will notify to the responsible person about the suspension. When the importer receives the notification letter of suspension, and if he or she is not satisfied with the suspension order, he can apply to the court for reviewing, modifying, revoking, or confirmation of the suspension, which was made by customs. If the court revoke on customs suspension, customs will terminate the suspension, and we will allow importer for the release of the goods. So the importer can pay duty and taxes for their importation. And if one applicant receives the notification letter of suspension order from customs, they need to apply to the court for the merits of the case. So for the action, they need to apply or they need to notify to customs office as well for their action. So if we are informed by the applicant, we will wait the court decision and then take action according to the court's decision. Otherwise, we will terminate the suspension order and allow importer to allow importer for their importation. If the court determined the goods are genuine one, the applicant need to pay compensation to the importer, and the customs will terminate the suspension order and allow importer for their importation. If the court determine the goods are counterfeit one, the customs will take action according to the court decisions, and for the destruction or disposal of the infringing goods, importer need to pay the cost. So this is the overall process about the recordation or suspension. For both application process, the applicant need to pay security deposit. For recordation, which will be made under Rules Chapter 2, they need to use the Form 1, which can be downloaded from the customs website. So for this procedure, the applicant need to provide the security deposit after suspension. So in this case, customs will issue suspension order firstly, and after we issue the suspension order, within 15 days, the applicant need to provide security deposits to customs office. For suspension, for application of suspension under Rules Chapter 3, they need to use Form 5, Form number 5, which can also download it from our website. In this case, the applicant should provide the security deposit before suspension of suspended goods. So in this case, when we grant, when the customs officers notify for the granting of the application, so when they receive the letter from customs, and within 5 working days, they need to provide security deposits. Otherwise, we won't issue the suspension order when the suspended goods are entering into the country. So what was the difference between those two application process? For recordation process, applicant need to provide general information. So you can check it out later because we already uploaded on website. So in that case, you just need to give general information. For example, about the like company address or name, or brand, and the contact number, and etc. And for application for suspension order, the applicant need to give more detailed information. In that case, what kind of information will be like the suspended goods will enter into Myanmar on which day or by which shipment, or the importer will be who and who, or something like that. So it depends for the applicant. If you can provide all the necessary information under Rules 2, you can proceed this recordation procedure. Or if you can provide more detailed information, you can go directly to the suspension order. Current Myanmar trademark law stipulated only for importation goods, not for exporting goods. So in this case, customs will take action for exported goods under C Custom Act Section 18D. This was the difference between the TRIPS agreement and Myanmar practice. So in this case, the accepting application for or suspension order, we customs will do, and we customs issue the suspension order. And for the merits of the case, the court will make decision, and we will do the border enforcement for copyright and trademark. And currently, the trademark law mentioned about import for the expedition, as I mentioned. For expedition, as I mentioned before, we will take action under the Custom Act. So for time saving, I'm going to skip for some point and I will go directly to the main point. So, okay, for this one, I'm going to skip. And okay, for the security deposit, the applicant needs to provide 10% of custom value, or it's like about 5,000 US dollar, and which will be decided by DG, and depends on case by case, and which will be announced. This information will be announced on our website as well. Now we already reported to our DG, and after he signed, we will publicize on our website as well. Okay, for the suspension, duration of suspension, as I mentioned before on my flow chart, the applicant needs to inform to the customs to the customs department whether they are initiating the court process or not. In this case, if they notify to the customs department, we will continue the suspension. Otherwise, we will terminate the suspension. And for the time frame, we will wait 15 days for general cargo and just 3 days for perishable goods. So please be aware of this days. For perishable goods, we have very limited time. And for the distribution of the goods, firstly, the importer need to pay all the costs. In case if the importer failed to pay the cost, the right holder is responsible to pay all the costs. And after that, we will refund all the security deposits to the right holder. And for the right of inspection and information, yes, we customs allow importers and right holders to inspect the goods after we issue the suspension order. Yes, according to the TRIPS Article 58, we have ex-official power. So to support this action, we recommend applicant to do the application process right after you receive approval from the IP department. Otherwise, it may take time for the custom officers to differentiate between the genuine and counterfeit one. Yeah, for destroying the goods, we custom lead the whole process and taking action according to the court decision. For the border enforcement, we will exclude for those items, which is for non-commercial, like express cargo, and for sample and personal allowance, which are not for commercial one, and transshipment cargo, reshipment cargo, redaction cargo, and transit trade cargo. For those goods, we will exclude from the border enforcement process. Yep, currently, we are facing many difficulties, as mentioned Mr. Aung Khine OO before. And among them, 3 main challenges I'm going to mention about. The first will be the mindset. For custom officers, currently we are mainly focused on collecting duty and taxes, not on IP matters. So we need to change the customs officer mindset. And for the consumers, they just care about to fulfill their needs because they have limited budget or some other reason. So we need to change not only to the enforcement or officers and for the consumers as well. The second one is lack of operational capability on IP border enforcement. As I mentioned on my organization structure, currently we have just 4 IP experts in my department. So we are recruiting some new officers and giving training to them. And this IP practice is very new, not only to our department and others as well. So we are at the preparation stage. So we need to make clear guidelines and clear instruction to the customs officers. So the future plan will be, we are going to standardize and harmonize procedures for customs to support those IP laws. And we need to make a lot of awareness and training program for the custom officer. And also to change the public mindset, we need to make public awareness by cooperating with other government department and right holders. And this is my contact information. So if you have any questions, if you have now, you can ask me right now, or if you have later, you can reach me through this email address. And this is our website. So for our customs rule, you can download it from here. Yeah, thank you very much for your time.
Thank you, Ms. Htwe. The next speaker is Ms. Khin Saw, who will talk to us about the civil and criminal liability under the new trademark law. Over to you, Ms. Khin Saw.
Hello, everybody. So good
Hello.
afternoon.
Yes, we can see that perfectly.
Yeah. So I'm Khin Saw from Law Plus Myanmar. Today I will present of the criminal and civil action for the trademark law. So before introducing the rights of the registered mark under the trademark law. So after the registration of the mark in Myanmar under the trademark law, so the owner or the right holder can use the registered mark with the registered goods and services during the registration period. So the term of the registration period under the Myanmar law is for the 10 years each, and it can be extended for the next 10 years each. And then the right holder can prevent from the using identical or similar marks for the identical or similar goods and services by other party without other organization, authorization and cost of the trade, and such use mislead the public. Then the right holder can find the lawsuit by the criminal proceeding or the civil proceeding, or the criminal and civil proceeding both against the infringer on the rights of the registered trademark. Moreover, the right holder can prevent from using the identical or the similar or the registered well-known mark using from the different goods and services without consent of the owner. And then the right holder or the owner can transfer the registered mark by assignment of the license to the other person. So, and next slide, I will refer the TML for the trademark law. So if any person can face the infringement of the trademark, so can find the civil or the criminal suit with the IB code. So as you know, the trademark law had got into force 1st April 2023. Before the enforcement of the trademark law, the Union Supreme Court issued the 5 notifications on the March 24. So Union Supreme Court of the Myanmar provide the authority to the relevant court to act as the intellectual property code. So under the Union Supreme Court of the Myanmar issued the notification to 35 to provide the authority to the High Court of the Yangon region for handling the miscellaneous cases against the decision of the Intellectual Property Agency under the Section 66, and also handling the miscellaneous cases on the suspension order issued by the Customs Department under the Section 72 of the Trademark Law. These Intellectual Property Agency and the Customs Department are the administrative body, and then their decision must be in the correct on the procedural mistake. So the Union Supreme Court provides the authority to the High Court of the Yangon region for this purpose. Moreover, the Union Supreme Court provides the authority for the criminal cases original jurisdiction to the district court and also the court of the sub-administrative division and the court of the sub-administrative zone to handle the original jurisdiction for the criminal cases. And then any person unsatisfying the decision of these criminal cases can apply the appeal of the decision to the High Court or in the relevant state in the relevant region under the notification 237. Moreover, the Union Supreme Court provides the authority to the Chowdhury District Court for handling the original jurisdiction of the civil cases for the civil original suit for the infringement of intellectual property rights, and also handling the miscellaneous cases for the provision and measure order to prevent the infringed goods enter into the trade channel under the notification 238. Finally, the Union Supreme Court provides the authority to the High Court of the Yangon region under the notification to enter the revision against the decision can find the civil cases as per the slide, which goes and handle the trademark law. Mention that the right holder can take for the intellectual property rights. In the sections, the holder can find the counsel for the register mark. The holder miscellaneous cases for the entity or the trademark law under the civil proceeding. But the provision of the trademark law limit harm to find the criminal offense. In Section 94B said that the criminal offense related with the marks must be taken action under the provision of the trademark law only. So the right holder must note to find the criminal offense. So this criminal offense must be taken action under the trademark law, not fine under the Penal Code 4 said that the dispute rising out between the mark owner or the right holder can be settled the mutually negotiation or by the arbitration procedure or by the court proceeding. So the right holder can settlement these methods. And then the provision of the trademark laws. The IBC, why the IBC is the practicing civil and the criminal cases. The IBC can use in the exercise as required as the provision of the evidence as or the civil procedure code or the criminal procedure code and also other related or if not provided in this trademark law for the infringement of the registered mark. So IBC can accept the evidence submitted by the parties under the provision of the Evidence Acts. Moreover, the provision of the trademark law provided authority to the IBC to issue the provisional measure order under the civil proceeding. So we can ask the question that when the IBC can issue the provisional measure order, the IBC can issue the provisional measure order before decide the final decision as required as. So IBC can issue the one or more provisional measure order in the linear case filed under the section 77A of the trademark law under the civil proceeding. So IBC can issue suitable order for the protection of the infringement and for prevention from the infringement goods and into the state trade channel. And also in the evidence as the original position. Some of the evidence easy described shortly. So IBC can control the evidence as their original position. So IBC can order for this purpose. And then IBC can order to approve or to remove or to reverse the order issued by the customer. Moreover, the IBC can issue provisional measure order and export when the IBC can do an AD if and may order and damages.
I think there may have been some network problems, and Ms. Khin OO is now offline, I think. Never mind, because we have, she's
Sorry.
coming back. Right. Yeah.
Is the so I will continue.
Yes, please continue.
So IBC can issue the provisional measure order in the expert deed if there any delay which
Now, in the interest of time, while we're waiting for Ms. Khin OO to come back and continue to deliver her part, let's take the chance to answer some of the questions that you have posted in the Q&A box. So could all speakers, whoever will be able to help with the questions, please just unmute yourself and provide the answers to us online, live. Okay.
Yeah.
No.
Sorry.
Oh, okay, you're back. Right.
Yeah. Sorry, the connection is not good currently. So I will continue.
Yes, please.
The provision of the trademark law. Yeah. So I mentioned define the infringement of the trademark and define the infringement of the trademarks. If any other person who is not the owner of the registered marks use and practice any rights of the registered trademark mentioned in the section 38A without consent of the owner of the trademark within the union. So it's breaching the intellectual property code, share reason it is the infringement of the trademarks. And then if any person is using an registered identity or the similar well-known mark using with the identity or the similar goods and services without consent of the owner or the right holder. So in this the IBC the authority to issue the relevant order. The IBC can issue the one or more of the relevant order under the section 77A and the subsection. So IBC can issue the injunction order for the suspension of the infringed goods entered into the trade channel of the union. Can also IBC decide to pay the sufficient remedy for the damages or the rights holder or the profits obtained by the infringer or the both. The IBC can decide to pay for the costs, including the court fee and the lawyer fee for the right holders. And also IBC can issue the order for destruction or the removal of the infringed good, and also destruction or the removal of the instrument mainly used in the making in the trade goods from the market. But Section 82 says that the applicant find false complaint and bad faith. So if the applicant find false complaint and bad faith and the respondent who wrongfully prevent, so IBC can issue the order to pay the damages, including the court fee and the attorney fee to the respondent who wrongfully prevent. The plaintiffs of the right holder, if find the civil suit and claim the remedy to covering the damages. So the right holder can claim the remedy as of the injunction to issue the injunction order to prevent the infringed goods enter into the trade channel of the union, and then can claim the sufficient remedy for covering its damages, and then can claim the costs, including the court fees and the lawyer fees, and also can claim the to destruct or to remove the infringed goods, and also destruction or the removal of the instrument mainly used in the making infringement of the trademark from the market. The plaintiffs claim the remedy, so plaintiff must attach the evidence. So if the right holder claim the remedy in the civil suit, so he needs to approve. He is the right holder or the owner, and he must attach the evidence that shows he or she is a right holder or the owner. So, for example, the trademark registration certificate, it says he is right holder or the owner, and then the recording or the assignment or the recording of the license, and then a copy of the registered declaration of trademark ownership, and then other publishing cautionary notice. So these can be attached to prove his or he is a right holder. And then the right holders must attach a document which shows the similarity of the defendant marks. And then if the defendant using the similarity of the infringed mark, so defendant's effect is business, appear the loss. So the plaintiffs must attach with the evidence shown that it affects the defendants using it affect its business. And then the defendant using cause to the public confusing, and the defendant using is the intentionally or the negligent or the defendants. And moreover, the right holder should attach with the evidence related for the calculation of the damages and causes. For example, MYINT or the issue or the list or the sale goods and other related documents. It is the public confusing, and it is the infringement of the trademark and the cases. So we will go to the criminal action under the trademark law. If any person commits the imitation of the mark or use of the counterfeit mark or the kit or store the tool or the instrument mainly used in the making the imitation of the mark, and this action for the commercial purpose without consent of the right holder. For this offense, the punishment shall be imprisonment for a term not exceeding 3 years, or the fine not more than the 5 million just or both imprisonment and fine. So any person sell or trade goods the using counterfeit marks or keeping in possession or the store the counterfeit goods or import or export counterfeit goods. For this offense, the punishment shall be imprisonment for a term no more than the 2 years, or a fine no more than the 5 million just or the both imprisonment and fine. The offense mentioned in the section 87. So any person commit again and again same offense mentioned in the section 87. The punishment shall be imprisonment for a term from a minimum of 3 years to the maximum of the 10 years and plus a fine with the 10 million just. So this punishment, both imprisonment and fine. So if any person use the flash or the emblem as a mark for the commercial purpose, this flash and emblem specially brought under the international agreement, and our Myanmar country enter into this international agreement as a member. For this offense, the punishment shall be not more than the 3-year imprisonment and a fine or the 5 million just or the both imprisonment and fine. And then any person of the removing something from the register mark or destroying the register mark or defining or the adding something at the register mark for intentionally affect to the owner of the mark. For this offense, the punishment shall be not more than 1 year imprisonment or a fine or the 3 million just or the both imprisonment and fine. Section 91. It is related with the issue the mark registration certificate. So any person incorrectly issue the mark registration certificate or allowed to incorrectly issue the mark registration certificate, or any person conduct in bad faith to force entry in the register of the mark or the forced to conduct forced entry in the register of the mark, or any person using cancel mark by the register or refuse mark by the register. For this offense, the punishment shall be no more than 1 year imprisonment or the fine or 2 million just or the both imprisonment and the fine. And some other offense. The accused person have now commit themselves. They contribute in these cases as the competency or the abatement of the each offense. So for this offense, the penalty shall be same. The punishment shall be same penalty of the each offense specified under this law. So after registration under the Myanmar Trademark Law, the owner or the register or the owner of the right holder of the register of the trademark can find or can take the legal action, criminal or civil, under the Trademark Law, or civil and criminal cases under the Trademark Law. These are all in my presentation. Thank you very much for your attention.
Thank you very much, Ms. Khin So. So now we are quite pressed for time, so let's take a look at the Q&A session. Some questions have already been answered, so I would invite all those who posted questions in the Q&A box to please check the answered box as well. there are still some open questions, and could all speakers, whoever is able to answer the questions, please come up, unmute yourself and answer the question. Now, one question is, what is the trademark opposition process? Is it a contentious process? Will any of the speakers be able to answer? So, for example, is it just by filing papers, filing submissions, or will there be a substantive opposition hearing?
In opposition, it's like a very long process. So firstly, you need to apply for the opposition case, and then after receipt of the opposition case from IBD, you will need to submit a opposition letter, opposition description, something like that, into the maybe in writing, and then we will need to submit other relevant documents, and there will be some hearing if necessary. If it is decided by the registrar from IBD.
I see. Thank you. Now, I'm trying to go through the questions of the anonymous attendees first, because for those who have registered and left a name, we can answer you offline later on. And another question is, where would the trademarks be published by IPD? Is there a specific journal or gazette where the trademark applications are published?
Not yet.
Yes, Ms. Khin So.
Yes. So currently, the IBD, the Intellectual Property Department, had not announced the register mark, so we cannot search the database of the trademark department, IB department. So currently, it is not available for the trademark search under the database of the IB department.
I see. Okay.
Excuse me, may I
Yes.
add more answer
Yes.
to the previous question? Actually, the IP department mentioned about that question in other meeting or other webinar. They said they are going to mention the approved trademark on their website when they already review all the applications. So right now, we cannot search the approved trademark so far, but later they can search on their website as well.
I see. Okay.
Yeah.
Thank you.
Thank you.
And then there is a question about the criteria of well-known trademark. So is it well-known worldwide or well-known in Myanmar only, or both? So what will satisfy the criteria for becoming a well-known trademark protectable in Myanmar? So if nobody is taking this question,
Yeah, excuse me, Ms.
Yes.
Rebecca.
Yes.
In Myanmar trademark law, they mention about the well-known mark and okay. Under section 2P, they mention like well-known mark means any mark that is well-known in the state according to the prescribed criteria. So in this case, it's like well-known in Myanmar, not well-known in worldwide.
I see. Thank you very much.
You're welcome.
Okay. And then There's another question from an anonymous attendee. If we did file a recorder of change of IP agent, or I mean the representative, for refiled applications online, but it hasn't been recorded, whether the old IP representative can withdraw such refiled applications which were previously filed through them? Does anybody have any answer to that? It's about the change of representative.
I think only Miss Momo can answer this question.
I see. So maybe we will wait for Dr. Momo Htwe to come back to us on this. Right. Another question is, can assignment request be filed for applications whose official fees and TM Form 2 has been filed in second phase? I suppose that means it has been published, but not yet registered. So can you record an assignment for that application?
Yes. So
Yes, you can.
Yeah, assignment can be signed, can be filed for the application. So filing the TN4 or TN12 form.
Okay.
After being the official fees and the notified TM2 form and second page. Yes.
Right. Thank you. Now, if registration of a mark is in black and white, use of the mark in different colors, all right, is in different colors, would the registration be exposed to the risk of expungement on the ground of non-use? So you register the mark in black and white, but you use the mark in color. So will the use of the mark in color constitute use to prevent a registration of the mark in black and white from being expunged on the ground of non-use?
So I understand that this question should be the answer by the IB department because there is the procedure of the examination of the register.
I see. So we will again leave that to Dr. Momo Htwe. I think. Oh, so we have come to the last question. Is the filing date the same as the registration date? If not, then the 10 years renewal will be counted from which date? That is to say, the filing date or the actual registration date?
The trademarks, the IB department, the alarm, find the application and the filing date, specify the filing date. So, and then this filing date, the registration as the registration date. So if not, then the 10-year renewal, when renewal. So renewal before the expire date. So it may be 25th April 2023 is the filing date. So it will grant the IB department as the registration date. So next 10 years, so before the expire date, can they renew this trademark within the 6 months? Can we renew for the renewal? So count that this maybe the 26th April. So 25th April of the next 10 years, 2033. So 25th April 2033, maybe the next 10 years renewal. I
Right.
understand like that.
Yes, I understand. So it counts actually the anniversary of the filing date. The renewal will be the anniversary, 10th year anniversary of the filing date. So a follow-up question. Is there provision for late renewal? Is there any grace period for late renewal?
Yeah. So the IP department allowed that 5 years next, as 6 months before that, we need to define the renewal. So before the expire within the 6 months. So if not, refine the renewal within the 6 months. So the IBC allow the next 6 months for the period to find the trademark renewal. So if not, in the 6 months, this may be this make the registration of the trademark.
Right.
It's not find within this month.
Right.
So it's called the one of the usage. So I don't remember. Sorry.
Yes. So the next question is, with regard to non-use cancellation, all right? When will the period of non-use count? When will that start? Is it from the registration date, which is the same as the application date? Or is it only when the mark is really registered? Then you count the non-use period. So is it the registration date or the actual grant date?
So in the trademark law, so non-use, the 3 years continuously non-use will be the cancel from the registrar under the trademark law. So 3 years, the owner of the trademark must use this registrar marks during the registration periods, but not use. Continuously the 3 years. It is the non-use cancellation. So the registrar can cancel the non-use trademark from the registrar.
Yes, my question is, when is the earliest date when a trademark registration becomes vulnerable to cancellation? Is it from the 3rd anniversary of the actual grant date or the 3rd anniversary of the registration date, which is the same as the filing date? So which date do you count the 3 years? Of course, afterwards, right? The 3 years is continuous. So any period of 3 years of non-use, your mark is vulnerable to cancellation. But when is the first vulnerability date? Is it the 3rd anniversary of the registration date, stroke filing date, or is it the 3rd anniversary of the grant date?
So it may be the answer by the IP department, I think.
I see. So, yes. So I think we have already, let me see. Yeah. So I think we have come to the end of all the questions that can be answered by the speakers present in the room. So for the other questions that need to be answered by the Director General of the IPD, we will convey the questions to her and see whether there will be some means of answering the questions. Of course, at the very beginning, I requested people who posted questions to put their name and email address so that the reply can be sent to them. But if they remain anonymous, I do not know whether there will be a way that we can reach out to you. So, but anyway, we have now come to the close of the webinar. So let me thank again all the speakers for your sharing, And a special thanks to the Myanmar recognized group and in particular, the group president, Ms. Aung OO, for helping us organize this very informative webinar. And to all participants, I hope you enjoyed the webinar and you will come back for the next episode of the Trademark Caravan, when we will bring you the trademark law and enforcement of another jurisdiction. So until then, have a very good day. Bye-bye.
Thank you. Bye-bye.
Thank you. Bye-bye.
Thank you. Bye-bye.
Thank you, Rebecca.
Thank you.
Thank you, all participants. Yes.
Yes, thank you.
Bye-bye.